recorded live.
All right, well, welcome everyone to the call. I apologize for the delay. Believe it or not, I was sitting downstairs eating dinner with my family, and I just totally spaced it, so I apologize for that. Just a quick disclaimer, we are not attorneys. We do not provide any legal advice. This is not to be construed as a call telling people what to do. What we are all about is the truth, talking about living on the land as free men and women. So if you hear anything on this call tonight, it's for entertainment purposes only. Do not take anything we say as the truth. You need to go search it out for yourself. If anything that you hear or you decide to do based on the information you receive from this call or from the Free Americans Yahoo group, you need to own it. If you sign it and you put your energy behind it, it's yours. You need to defend it. But we do love talking about truth and talking about the things that help us become free men and women. And so with that said, at this time I'd like to turn it over to Christian to continue our discussion regarding trusts. Go ahead, Christian.
Okay, can you hear me okay?
Yeah, you sound great.
All right. So last week we were talking about the expression of the trust, the intent, and we're going to continue on. I'll do a little recap of that, and we're going to talk about trust property, the res. But under the expression of the trust and under the intent, oh, by the way, I've got a new announcement to make. Formally, I'm making an announcement on Saturday on my show about a new remedy. And I'm going to be previewing it here on the show tonight, so this is kind of like the pre-announcement, I guess, or the pre-grand opening. So the expression of the trust and the intent, what we went over last week, was really that anytime you sign your signature, you're forming a relationship, and it needs to be a trust relationship expressed, or it could be another type of relationship, and that which might lack some of the elements of the trust. And the trust is really like the 900-pound gorilla, and you're wondering why you get flipped in court and why you lose all your court battles and that, but you're getting flipped by a trust. And all these Article III courts supposedly are not Article III courts, and we really thought that they were administrative courts, which they are kind of functioning as that under commerce, but really these are all trust courts. So in general, it's the specific intention that a trust should immediately arise with respect to some particular. And then there's the form of expression, which is by words. That can be oral or written, or by conduct. And that's the bingo one there, the conduct. You can get your conduct by silence. Silence can be conduct. And the wording is there's really no particular words are required, and the term trust need not even be used. And nor is it essential that the settler or any other parties involved know or understand that the intended relationship is a trust. That's the bingo. And that one there's the wow. Because if the courts could find that the parties intended to form a certain relationship with respect to a particular property involved, if the law defines that that relationship is a trust, then the party's intention to enter that relationship provides the requested trust intent. So, although the parties do not have to know or understand what they're getting into, if they by chance had all the elements of a trust in there, and that qualifies under the law as being a trust, it is a trust. Now, that's what they're getting you in court at. You're not coming in and recognizing it to be a trust. And I've got some court documentation, some transcripts from different cases where the actual parties are saying, he's trying to explain about house joint resolution and it's a trust and everything, and Social Security, cesticate account and everything. And the judge comes back and says, there's no trust here. And then that party says nothing. Well, there was your opening for bringing in your expression of the trust, but you never recognized it. And since you didn't express the trust, then it was construed not to be a trust. and then the court's going to take silent judicial notice that you're the trustee on this so-called trust that they're going to construe in the silent, and then you didn't make the payment with Federal Reserve notes, and you're going to wind up a trustee in prison. So the particular wording doesn't have to be using trust, or you don't have to know or understand that the intended relationship is a trust. It still forms a trust. And the use of the term trust may refer to their relationship as a trust, but if the requested intentions are lacking or an essential element is missing and not to be provided by the court then, that's key, then there is no trust. So if the court supplies a missing party, say, or expresses the trust themselves, really what they do is they construe it, or forms a resulting trust. And trust formed even though you didn't express it, but it's biased bent on the courts and for their own benefit. So there's communications, which is external expression. So there has to be some kind of admissible evidence that the settler's failure to communicate the trust intention to the beneficiary or others does not prevent the trust from arising. So even though you didn't express the trust, say, that doesn't negate the form of the trust from forming. So then precatory expressions of intent or weak language, which is not direct or commanding, it's definite, specific, it's not detailed. So usually the settler directs or commands the trustee to manage the property for another, and words like hope or wish or suggestion that it may be used such and such a way is weak language, and it's going to be construed, allows the door open for the construement of the trust. So it's called precatory language. Whether precatory expression creates a trust or only unenforceable moral obligations, more or less, is a matter of interpretation. So there's where the construement comes in. The court's a matter for the court to determine what the transferor intended. So that's why it's important not to use weak language, precatory language. And then there's the evidence of a trust intent, where precatory words are interpreted in context coupled with other words. The court may find sufficient trust intent. So the following evidence or circumstances may be relevant. Number one, definiteness. The court will examine the instructions to see whether the alleged trustee, if they are definite, specific, and detailed, and the more definite, specific, or detailed the instructions, the more likely it will be held that the trust was intended. So fiduciaries, the court will consider whether the instructions are addressed to someone who otherwise stands in a fiduciary capacity. And that's one of the other relationships that is not a trust. It could be an administrator or executor, fiduciary, bailment is another one. These are other types of relationships which are not trust, but they have this similar looking, but they're missing one of the elements necessary. So it's the language addressed to a fiduciary is more likely to be treated as expressing a trust intent, and the language addressed merely as a legatee or divisee is less likely to be held to express trust intent. Then there's time and place. If there's anything about the word later in there, then is increasing the likelihood that there was a trust formed, because a trust intent has to be now, present tense, and transfer, present transfer. So time when a trust intent must be expressed, and the general rule is that the intention to create a trust must exist and be manifested by words or conduct at a time when the settler owns or is transferring the intended res. So we have gifts. The settler cannot convey property as an outright gift and later execute the trust instrument declaring the gift was actually a trust. And after acquired property, where a voluntary trust intent is held and expressed by a person purporting to be the settler prior to their acquisition of the intended trust property, courts will probably find this to be sufficient manifestation of intent to create a trust if there is some further manifestation of trust intent by that person, either by conduct or by words, after acquiring the property, consistent with prior expression, for example, would be a subsequent conduct, would be established by a declaration, and the purchase of a property for the trust would then be the subsequent conduct. So a trust might be intended to take effect immediately. Another factor to consider in determining whether a trust has been effectively created is at the time when the trust was intended to take effect. The settlor must intend the trust to take effect immediately, even if subject to revocation, and not at some future time. So a trust to be created by transfer here, by a transfer in the future, there is no trust. And it's going to fail for a lack of present intention or for a lack of essential present transfer. So a subsequent action, and this would be by a transfer or a declaration, if our were is appropriate subsequent act, that be of a transfer or in the case a declaration of segregating the res, that is consistent with their previously stated intention and with an intent that the trust presently take effect, a valid trust will then arise. So we have the effect of postponing designation of essential elements. So the four basic elements to form a trust are intent and purpose, 1 and 2 by the grantor, and specific trust res, 3, and 4, the last one would be parties. So the effect of postponing designation of essential elements. So if any of those four elements are missing, here's the effect. If the owner of a property executes an instrument purporting to create a trust, but providing that the beneficiaries, the trustees, and the beneficiary, the trustee or the trustees are to be designated later, the incomplete terms or the left out terms of the trust are evidence that the settlor intended a trust only in the future and would be no present trust. So that would be the non-expression of the trust construed puts you back under the debtor-creditor relationship under a debt. And the example of that would be in that case I was talking about on the transcripts where the judge, the defendant was talking about the trust, house joint resolution that was formed and everything, Social Security account, and the judge says that there is no trust here, and then you say nothing, so there was no expression of the intent in the parties or the res, etc., because you didn't say anything, an expression of the elements, you're missing the elements of the trust, and the method of formation, example by transfer, then this trust is going to be construed to be no trust. And you missed your opportunity. So trust of future intent. So as long as the trust takes effect immediately, the trust res itself may consist partly or entirely of a presently existent future interest. And there can be trust promise. An unenforceable promise to create a trust in the future does not create a trust. There is neither a present transfer nor an intention to create a present trust, although it may be created in the future. And then the effect of consideration. If consideration is given, so that would be the property, is given for a promise, and that promise might be, say, discharge our debts according to House Joint Resolution 192. So if consideration is given for a promise that is otherwise enforceable at law, example by damages, or in equity, example by specific performance, that would be the discharge of the debt, then the intended beneficiary's rights can be enforced. So the better view probably is that the promise itself being viewed as creating no actual trust for lack of present transfer, there is an enforceable right, though, to have a transfer made and the agreed trust established at a later date. And another interpretation of the situation would view it as creating a present trust of a truce in action with an enforceable promise as the res. So now we come down to where we left off, trust property, or the res, next. So the requirements in general here is there are three generally stated requirements for the trust property, or res, and it must be, number one, the existing interest in a property. In other words, you have to own it. Two, capable of ownership and alienation or transfer. And three, sufficiently identifiable or identified. So number two, interest in the property now. The res must be an existing interest in existing property, real or personal, tangible or intangible. The interest held in trust may be present or future interest, possessory, and that could be a possessory title, which most tenants on the land are, thinking that they own their property, possessory or non-possessory, vested or contingent. And under A of that subsection there, it says mere expectancy insufficient. An interest that has not yet come into existence, a mere expectancy, cannot be a trust res because the settler does not have the property. So example, the daughter declares she holds, quote, a property that I may inherit from my father, who is still alive, by the way, in trust for a friend's child. Daughter has not created a valid trust, nor can daughter transfer such an expectancy to trustee in trust. She doesn't own the property yet. So also compare, if the father had been dead when the transfer was made, however, there would be a valid trust because the daughter's interest in the estate would be an existing property, even if the father's estate had not yet been administered. So here's an example tip. Watch out for questions in which the trust res consists of property that the settler does not currently possess. A future interest, such as a remainder, can be held in trust because it is presently existing, legally protected right in the property, although possession may be postponed until the future. However, a mere expectancy, that is, not yet in legal existence, cannot be held in trust. Okay, now manifestation again after acquisition. So if the daughter again manifests her present intention by declaring a trust of the inherited property after it is acquired, this will create a trust at that time. But the later declaration is not retroactive to the earlier expression of intention, a potentially important point because it fixes the date for the existence of the trust rights and duties. And now consideration. If a friend has paid consideration for daughter's declaration of a trust in assets to be subsequently acquired, however, the courts would probably treat the transaction as a contract to create a trust. When the assets are actually acquired, the contract can be specifically enforced even if daughter has changed her mind. So example tip, remember that consideration is not required to create a trust, but it can cause an otherwise unenforceable gratuitous promise to create a trust in the future to be unenforceable under contract principles. Sounds like what they're doing with us. They're really operating by colorable contracts, but really it's trust all along. So now we're going to jump to equitable interest. The res may consist of equitable interest, that is, interest of a trust beneficiary, if assignable, can be transferred into another trust. Now that example would be the Foreign Situs Trust birth certificate, which is kind of like an overflow trust, that when you came 18 years of age, all the assets overflowed into the Cess Decay Trust, the Social Security account. So if it was assignable, it can be transferred into another trust and held as the res of the second trust for the benefit of others. And in such a case, the trustee of the second trust does not have legal title to the res, he has paramount equitable title, while the beneficiaries of the second trust are said to have subordinate equitable title. The equitable interest placed in the second trust may be a present or future interest, and if the latter, future interest, it can be vested or contingent as long as local law recognizes the interest as transferable. And alienability or transferability. Because trusts are created only by some form of transfer by the settler, even if the form of declaration passing title from the settler individually to the settler in her fiduciary capacity. It is usually, if somewhat casually stated, that a standard doctrine that the interest held in trust must be alienable. In other words, it must be transferable. If you can't transfer a property, you can't form a trust, according to statutory law. I'll stress that, statutory law. Okay, common law. At early common law, certain future interests, possibly a reverter and a contingent remainders, were non-alienable and therefore could not be transferred into a trust. Although, example, the retention of a revisionary interest in the trust estate after transfer by the transferee of a fee simple determinable or other interest in trust property that is less than that held in trust was permissible. And today, however, in most states, all future interests are freely alienable and may be placed in trust. Where this is not so, the old disability remains. And now, inalienability be property. So I wonder how that word compares to the Declaration of Independence where it says unalienable. So, inalienable property. Certain other types of property are not alienable and hence cannot be transferred into a trust. And that example would be certain tort causes of action in some states or interests of beneficiaries of a spendthrift trust. And now a spendthrift trust is a beneficiary that has by indenture specified that they can't transfer the benefits. That's a spendthrift trust. But note, strictly speaking, the standard doctrine referred to above applies to transfers into trust and not to whether inalienable property can be held as a trust, res. Thus, if an inalienable cause of action arose in the trust, it could be held as a trust asset. And now number 4, identified or identifiable property. The trust res must be specific property that is actually identified or is described with sufficient certainty that it is identifiable, that it can be ascertained from existing facts. So thus it is often said that the trust property must be segregated, but the term is used to indicate the need for certain identifiable res, not to preclude a trust of an undivided interest. An example, settlor declares herself trustee of the, quote, bulk of my securities. The description is too indefinite and the trust is not created. But a declaration as to, quote, all of my securities except my U.S. steel stock would be, because by taking inventory of the settlor's securities on the date of the declaration and excluding the U.S. steel stock, the identity of the trust estate could be established with particularity. So fractional interest. The trust res may consist of fractional undivided interest in specific land. That would be 1/3 interest in, say, Blackacre, or goods, example, 1/2 ownership of my law library. So similarly, in an assignment of 40% of the funds in my savings account at National Bank, unquote, to another as trustee would be effective to create a trust of an undivided interest in the account as it exists on the date of the assignment. And now B, the share of fungible goods. Some doubt may still exist, however, where a trust is sought to be created in a portion of certain fungible goods, that is, cash or goods, where each item by its nature deemed to be the commercial equivalent of every other. An example of that would be barrels of oil or bushels of wheat of a certain grade or quality. And now the example, settlor having $200 in bills in her pocket, or even an amount that she is uncertain of at the moment, declares that she holds $100 of these bills for beneficiary. Is this a valid trust? The answer here is probably yes, but some authorities still leave some doubt. So here it is. If you have some specific, the same ones that you want back, then definitely that would be a yes. If you specified that things should be commingled, that you want to put in-kind in and get in-kind out, the exact thing that you put in out. An example of that would be promissory note in trust deposit, same promissory note back out of deposit, unaltered, unendorsed. Now, segregation. There should be sufficient segregation for this purpose if, as in the above example, or where a stated number of barrels of oils or bushels of wheat are to come from a particular oil tank or wheat bin, the trust property is identifiable as undivided interest in or a determinable fractional share of or a larger identifiable or identified supply of a particular fund or mass of fungible items. And some courts, however, still may require that out of the fungible mass, there first must be some appropriation of the specific items to be held in trust. And that appropriation would be really transfer of title. Now see, obligor as trustee. So as a general rule, the obligor does not, by agreement with the obligee, calling for payment to a third person, become a trustee of what is simply his own debt. So there is no identifiable trust res, no segregation of funds, as the debt remains merely a general claim against the obligor. So let's plug in some different terms there. Let's just say as a general rule, the obligor, let's say the obligor is the bank, does not by agreement with the obligee, let's say that obligee is the depositor, calling for payment to a third person, become a trustee of what is simply his own debt, because the bank owes it back to the depositor. It's the bank's debt. So it is no identifiable trust res and no segregation of the funds. If that happens, then as the debt remains merely a general claim against the obligor, because he didn't express the trust. You didn't say it was a trust deposit or a special deposit. And a special deposit means trust deposit, which means that the funds are be held non-comminglable in kind out, in kind back. So illustration, insurance. An insurance company, while holding the proceeds of a matured policy and paying interest, is not the trustee of the funds. The beneficiary simply has a general unliquidated claim against the company rather than a right to any particular asset or fund. This is true where the proceeds are being held and paid pursuant to an annuity option or pension payment plan or similar arrangement, as long as no particular funds have been segregated or set apart by the company for this purpose. There's the key. As long as no particular funds have been segregated and set apart by the company for this purpose, because you guys didn't agree to it, and that's what happened. Nothing was done. So if the company fails, the beneficiaries have no priority over other creditors because nothing is held in trust for them. Likewise, if a beneficiary seeks modification of the agreement, even under the circumstance in which the court of equity could modify the terms of a trust, the petition would be denied. So what if the grantor does the modification? That's my question. And what if you came in expressing the trust as a grantor first? So 2, illustration, bank accounts. This principle has also been expressed in cases dealing with bank accounts. The problem arises where the bank is insolvent and the depositor seeks to establish that the bank was trustee of deposited funds in order to achieve some priority in distribution of bank assets. In other words, the trust funds held by an insolvent need not being part of the insolvent's estate. So the bank deposits, however, do not give rise to an identifiable trust res, and there is no segregation and no inferred expectation of segregation by the bank of monies deposited, and there is but a general claim against it for the amount deposited, plus interest, say. This has been held to be true even where the depositor called for the bank to hold the amount as trustee. But see, there was nothing specific about the res. You appointed the bank trustee, but you never specified the res segregation. If you would have segregated the res and appointed the bank trustee, now you have a special deposit, a trust deposit. And where the deposits have been specially marked or designated for a special purpose, but in either case with no actual segregation of the funds involved, then there is no trust. So examples, deposits of transmission of credit for payment for foreign debt in escrow and in special accounts. So a special account is probably where you make a special deposit, which would be a trust account. They're saying here that such special accounts probably create third-party beneficiary contracts, but not trusts. Probably because it's missing one of the 4 elements to create a trust. You just have an agency or a bailment or whatever other relationship. A few courts have been willing to find identifiable trust res in such cases, but the minority view has been criticized as perverting trust law to reach a desired result. So now, segregated funds, tying that in with these bank accounts. Segregated funds, a contrary result would follow if a trust were intended where the bank did specifically segregate the funds in question. An example would be by having the specific funds on deposit placed in a separate vault or separately invested. So now the obligee as trustee, and remember the obligee is the depositor. So as the rules in the preceding paragraphs apply where the bank is sought to be held as trustee for funds deposited, there is a little question that the depositor, the obligee, may hold the deposit, the debt, as trustee for another. And the deposit itself, the choose in action, is clearly an identifiable res. The depositor, therefore, can, by declaration or assignment, name herself or constitute another as trustee of the bank account. An example would be, quote, I hereby declare my trustee of savings account such number at XYZ Bank for the benefit of beneficiary named. Now, tontine trusts. The usual problem presented by the deposit is in one's own name as a trustee for another, however, is whether the depositor really intended to create a trust, and if so, upon what terms. It is also called a tontine trust problem. Now we come to special deposits. So problems may develop where special deposits, where the depositor later becomes insolvent and creditors seek to reach the monies earmarked in the special account. For example, monies deposited into a special account to pay dividends to shareholders have been held to be trust assets belonging to the shareholders, which would be the beneficiaries, and therefore not reachable by depositing corporations' creditors. But in a few dubious cases, similar deposits to pay employees' salaries or to pay coupon holders of corporate bonds have been held to be regularly non-trust assets of the corporation and hence reachable by creditors of the corporation. So note here that the special deposit under a debtor-creditor relationship as it pertains to insolvency and not trust deposits or deposit special deposits, which would be non-comminglable, and under trust deposit the creditors can't reach them. So what constitutes sufficient trust res? And there's a little two columns here, and the first column is the trust res may be, and the second column is the trust res may not be. So keep that in mind, what constitutes sufficient trust res. And under the may be column, it's future interest versus the may not be, mere expectancy. And then under the may be, it's promise supported by consideration, and the may not be is unenforceable gratuitous promise. And under the may be column, equitable interest, that is, beneficiary's interest in another trust. And under the may not be column, it says inalienable property, example, beneficiary's interest in a spendthrift trust. And under the may be column, fractional interest in specific property. And the may not be column, fractional interest in non-segregated property. And the last one, under the may be column, debtor's debt held by another. And under the may not be, debtor's own debt. And that's the relationship between what constitutes sufficient trust res as a summary. So next we'll get into parties to the trust. But here's where I want to stop, and I'll probably get into this next week. But now I want to give a formal announcement, and you heard it for the first time on this show. I want to introduce a new remedy, and that new remedy is called NTT. N period, T period, T period. And NTT stands for New Trust Technology. NTT, New Trust Technology, utilizing moving titles in commerce. So everything I've been teaching on my show, moving titles in commerce, the capstone on that pyramid is going to be NTT, New Trust Technology, as a new remedy. a new way of looking at this debtor-creditor relationship instead of looking at it under UCC, 14th Amendment citizen, administrative remedy, under commerce. It's actually functioning everything as a trust. And the more I study this, the deeper I get into it, I see it more clearly every day. And I can smell and I can see the remedy. This new trust technology, this NTT, can be applied to the termination of the cess-decay strawman account or just for claiming it, depending on what you want to do. If you just want to claim the account and still function under, say, the DTC or the Federal Reserve Board and have them disperse your assets with you putting in the documentation on what to discharge according to House Joint Resolution, then you have that option. Or you could come in and terminate the trust, pull all the funds out of the Social Security trust, get all the benefits out of it, all the assets, form your own trust, your own LLC, and operate in commerce totally outside with anybody else except you yourself operating it. Utilizing this new technology, this new trust technology, NTT, and utilizing moving titles and commerce along with it. You heard it for the first time on this show. I'm formally announcing this, and this is on recording on this date, Wednesday, November the 4th.
Christian, that is phenomenal. I'm sure our callers are excited to know how this can affect them and how they can utilize this for their benefit.
Okay, let me make a little announcement about my show on Saturday. The show time for Money, Banking, and Trust by Moving Titles and Commerce is every Saturday at 7 to 9 p.m. Eastern Time. And I'm the host of that show, and I discuss private educational program, whether it's in court or out of court or civil or criminal, or uncovering hidden roots causing all problems under public policy, aka bankruptcy or commerce, with the intent of examining the tools that we have available for achieving standing, gaining rights, interest, and titles through claiming our straw man or terminating the trust. And I address, for academic informational purpose only, hearings, investigations, arraignments, trials, arrests, kidnappings under color of law, whether it be credit card debt, property foreclosure, IRS tax liens, traffic tickets, arrest, and payment of all bills through private credit using promissory notes and money orders, utilizing ZYA and BIC methods, as well as UCC, GSA, and IRS forms as enforcement. And now if you grab a pen and paper, the call-in number for that show is 712-432-8773, and the passcode, or the PIN number, is 179441#. And again, that's every Saturday at 7 p.m. Eastern Time, and that also can be accessed from the Internet at the website www.therealpublicradio.net. And again, that is www.therealpublicradio.net. And we've had some problems with the server because the fellow who has the uplink has moved, but hopefully it might be up this Saturday. But I would suggest that you would call in using the number, the call-in number, instead of accessing on the show. If you wanted to ask questions, you have to dial in on the number anyway. So I might have asked on this show, I forget, maybe it was on my other show, but anyway, I asked some people about, think about a credit card application in respect to trust. And I don't know, that one's not quite fresh in my mind, but we did talk about a trust involving a dog. So where a party had been, they were issued a warning of a citation, and that the warning stated that the dog should be vaccinated and licensed, and the party didn't see the enforcement agent. They went into the house and didn't respond, and the the agent left a warning on the doorpost and gave them 30 days to have the dog vaccinated and licensed, or else probably what would issue next would be a citation. So now, if we would think about everything being trusts and gear our minds to the first question you have to ask is, what type of relationship is my signature forming here? What is the intent and purpose? Is it a trust which has specific elements in it to form a trust? And if it doesn't have those 4 specific elements, then it's another type of relationship, which could be fiduciary, agency, bailment, or others, executor, administrator, or something like that. And in particular, debtor-creditor relationship. Because if you're not expressing the trust, you're going to fall under one of these other relationships, and the one they usually put you under is the 14th Amendment citizen, debtor-creditor, under UCC, as the rules for the enforcement of commerce. And it's all about commerce. But the 900-pound gorilla is the trust that will immediately pin you to the floor. But if you don't express the trust, you can't be the 900-pound gorilla, and then they construe it that they are, and they pin you to the floor. Because all along you think it's debtor-creditor relationship when it's actually functioning as a trust. And remember what I read earlier, no party in the trust has to have knowledge or understanding that a trust is being formed. It does not negate the trust. And that was proved by that transcript in that case where that fellow was talking about the trust, and the judge says there is no trust here. So either he didn't know, which I find highly unlikely, or else he was waiting for you to see whether or not you knew that it was a trust. And now I hear everybody talking about you have to know who you are, but you have to know who you are under debtor-creditor UCC in order to make a claim. No, I think that's wrong. You have to know who you are as grantor of a trust. So it's what kind of relationship is your signature forming? Is it a trust relationship or is it just a regular agency relationship? Well, the question to ask is, number one, is all 4 elements of a trust available? Are they there? Number 1 being intent. Number 2, purpose. Number 3, parties. And the parties would be grantor, trustee, beneficiary. And then number 4, specific trust res. Something that's specifically identifiable or identified already. And then if you have all 4 of those elements, the next question to ask yourself is, do I have a formation of a trust? And a trust is formed by words, oral or written, or 2, by conduct, which can be your silence, which is an act or a conduct. And the 4 methods of formation of the trust are, number 1, declaration, which words or conduct declare. And number 2, transfer. And number 3, appointment. And number 4, contract. You have to have one of these 4 methods of formation along with the 4 elements to have a trust. And remember, you can have a trust and none of the parties know or understand they formed a trust.
Christian, what was that first one again?
Under the 4 methods?
It was, I didn't get the first one. The second one was transfer, third one was appointment, fourth one was contract.
Okay, the first one is declaration under the 4 methods. Number 1 is declaration, 2 is transfer, 3 is appointment, and 4 is contract.
Thank you.
And the 2 we really want to be keying in on is, number 1, declaration, and 2, transfer. So we could talk about transfer. Transfer is one of those portal words. It ports into UCC debtor-creditor relationship because there's transfer under Article 3, which is negotiable instruments, Part 200s, 3-200s, and that is negotiations. And transfer under negotiation there breaks down to 4 other methods under transfer, and that would be A, under endorsement, and B would be delivery in bearer form, and C would be assignment on a UCC3. That's key. And the last one, D, is by operation of law. So transfer breaks down to A, endorsement, B, delivery and bearer form, C, assignment, and D, operation of law. Transfer also is a portal word, porting into trust, because that's how you form a trust, by transfer, one of the methods. So you can form a trust by declaration, transfer, appointment, or contract. But transfer, you can form a trust by transfer, but you can also form a trust by UCC assignment. And really, that's basically what we're using to move titles. That's what moving titles in commerce is all about on my show. And again, keep in mind that no parties in the trust need to know or understand that they are forming a trust, neither the grantor, trustee, or beneficiary. It does not negate the trust. So you want to ask these questions. Establish what the relationship is. Is it a trust relationship? And are the four elements to create the trust there? 2. And 3, are the four methods there of formation there? One of the four methods. And then you have to have the basics down on how to create a title if there's not a title created. Because you have to have title to something, because you have to have present ownership. And how can you have present ownership unless you own it or you have ownership of the title? If you don't have the title, you don't possess it or don't own it, then you can't transfer it and you can't form a trust.
Hey, Christian.
So first you have to have title. If you don't have the title, you can create a title. Once you've created...
I'm sorry, I didn't mean to interrupt you. Do you want to field a question while you're talking through these definitions?
Yeah, we could talk about it a little bit as we go. Yeah, go on.
Okay, I got one caller that's got a question. Go ahead, you've been unmuted.
Yeah, Christian, what's the most simplistic way in expressing the trust? Most of this is probably new to some of us out there. Let's say you're involved in a certain case and you're going, oh, okay, yeah, this makes a lot of sense. So how can I go back in and amend what the assumption is and saying, here's how I'm going to express the case or express the trust in this particular situation?
Right. It's what I've been talking about here on these steps. You have to express the trust by specifying the four elements. And you have to have one of the four methods of formation. And you have to have the titles created and the title moved. And you move the title of the property, the specific res, to, say, the trustee. Now, once the transfer is effective on the transfer of the title, the trust is in existence and you've effectively expressed the trust. Yeah. And you don't even have to have any specific trust words in the expression, whether it be oral or written. And the parties that you're giving the trust to really don't have to know or understand at that particular time. If you understand UCC 1-202, which is notification, it says the same thing. You really don't have to have knowledge or understanding. It's the fact that I send it to you, that is notice of itself, and that makes you liable. So if I created a title and I did an assignment, which is really a transfer of a specific trust res on a UCC 3, and sent you certified notification of that, you don't even have to understand or know. You've been appointed trustee, and you've got the property, and a trust was formed, because that was my intent.
As the grantor.
Yeah, grantor's expressing the trust. That was my intent, but then I'm going to give it to the trust res, let's say the judge, and the judge says, okay, did you get my notice that I sent you? And he's going to say, well, I decline or disclaim the appointment, which is what they always do, don't they?
Mm-hmm.
Okay, what's the comeback for that? That's your open door for saying, well, okay, Judge, here's what we do. What happens is that when the judge refuses trusteeship or fiduciary appointment on a trust, the title reverts back to, or the specific res reverts back to the grantor. And he holds it as trustee as a resulting trust because it's been construed. The court is going to construe. When I'm in a court of equity will not deny the formation or the execution of a trust. It cannot. And it won't let a trust fail if properly formed. That means that the judge must appoint a trustee because he is under equity. In equity, he must appoint a trustee, a new trustee, a successor trustee. If he's going to refuse the duties of trustee, he must appoint another trustee. And then I'm going to direct him and command him to appoint a new trustee and inform me of who that party is so that I may do my duty as trustee now and move or transfer the title or the res property to the new appointed trustee.
Okay, that gives me a lot of clarity, and maybe that's why, because I know you saw some of my documents on a case that I submitted, and what I did, I revocated my position as trustee, and I actually named the judge and some officers of court as the trustee. And then what he did, he wouldn't allow me to submit any more papers into the case. Matter of fact, he had those sent back to me, which to me is tampering with evidence.
Okay, did he close the case? And what kind of instructions did you give him?
Oh, I sent him. Well, the thing is, I'm kind of like I'm not exactly sure at this point which is the proper way to kind of take this. And the premise was maybe I was coming in as a living man, and maybe there's some gray areas and
well, if you came in as a living man, they're going to construe you as a straw man, and really you want to be the straw man because the straw man is your remedy. He's the trust,
right? But you revocate that position as trustee, don't you?
Well, if I can't be the trustee, maybe in this court case, I want to appoint somebody else who can close the case, and that might not be myself. I would appoint the judge, and then he can appoint somebody else. If he doesn't want to be, he can appoint somebody else. Now he has official public notification of a judge that they're trustee, and then he's got to tell me so I can present the trust res property to the trustee so the trustee can now give it to the beneficiary.
Right.
So when the beneficiary has both sides of the title, because the beneficiary holds beneficial title already, when he receives the second part of the trust property, the possessory title, which is the legal title, now the two titles have been merged and the trust terminates. Because any party in the trust that holds both titles, the equitable title and the legal title, the titles have been merged and the trust terminates.
I see.
That would be the grantor or the trustee or the beneficiary. Anytime any one of those three parties holds both sides of the title, the trust terminates. And that's called merging of titles.
So you can't be grantor and beneficiary?
Yeah, you can be grantor and beneficiary, or you can be grantor and trustee, but you can't be all three at the same time.
So I don't like the trustee because it seems that's who they always go after, is the trustee.
Yeah, I would come into court being the grantor and the beneficiary and express the judge being the trustee. And then when he denies that or disclaims that position, then I would give him the instructions, okay, you are to appoint somebody and let me know who that appointment is so I can present them with the property, so I can transfer the property to them.
What if he refuses to appoint anybody, Christian?
Well, now he's in breach of fiduciary duty and he's in breach of trust. Now we got an equitable problem. We got a beneficial claim that the beneficiary can make. And then that beneficiary also has at-law remedies also, as well as equitable remedies.
And that's
equitable
kind of
remedies compel them to do the duty. And at-law remedies would be they can now lean up the judge himself and the court and the trust and lock up the trust in a constructive trust until the trustee decides to do his duty.
See, and that's kind of where I'm stuck, is where I can't file anything into that case anymore. And actually, this was a judge I had recused 5 years ago. He's still writing administrative orders, but so
I'm going to say this. I don't know exactly what all you did, but it looks to me like they're construing you back under a 14th Amendment citizen and under debtor-creditor, and they don't have to listen to you.
They can't, because there's already been a declaration of domicile set in there declaring who I am, and that's even under a good case in Florida. You look up Pat Prowley.
Okay, what was your... You got to come back and you got to analyze what you did. You got to analyze it. Do you have the four elements that are necessary for a trust? Do you have intent, purpose, parties, and specific res? And if you do, then you can go on to the next step. Did you use one of the formations, one of the four methods of formation? Did you do a declaration? Did you do a transfer? Did you do an appointment?
What we did, we made the Florida Attorney General...
I'm not done yet. Wait, stop.
Okay, sure.
Now, next thing. Did you deliver specific trust property to the trustee?
Yes.
What was it?
A $10 million indemnity bond.
And what proof do you have that you did that?
That was sent by notarial protest. The notary sent it to him.
So you have a certificate of notary protest on that?
Correct.
Okay. What did you do with that?
That went to the fiduciary, which was Bill McClellan, the Florida Attorney General.
Did you do a UCC-1 or a UCC-3, or did you do a county recording notice?
That was filed into the case, which is in the docket.
Oh, no. Of the instrument, the payment. Did you do a notification that a private instrument exists of such and such a number and record that into the county, pull that back out certified, creating a certified record of the notice, and then attaching that to your documentation? Did you do a UCC-1 on that also, which was a second notice of that, and then pull that out certified, and now you have two witnesses of a certification, a public certification, making that instrument now seeable in notice form, not the actual document, the notice of it, publicly recognizable.
So in other words, it goes.
And here's the key part. The key part now is: did you do a UCC-3 assignment of the property to them and pull that out certified? And then you sent them all that documentation records that you created of the facts that you established this trust. And did you do that by letter rogatory in chambers?
No, and no.
Transfer specific res property and no trustee.
I understand. So you're saying take that through that notarial protest with that private indemnity bond, file it into the official records. This way it becomes a certified official file, and then get copies of that, right, and then get copies of that, and then serve it upon them, and also file it with the state, the Florida UCC, and then do a UCC-3.
You need two records of claiming the title, which, as I told you first, two registrations, two public notices of registration, claiming the title, and then you need two notices of transfer of title.
Notices of title, and then two notices of transfer of title. Okay.
Otherwise, you can't prove that you transferred public property, and there's no public notification of any transfer of specific res property. No trust forms without transfer of property to the trustee. even though you sent him the note. There's no record of it, and no public notice of it that he can be seeing.
Other than that it's in the official docket.
Yeah, but that's putting it back to the public under the... did you record through the docket, the actual note?
Yes, yes, they received the actual note. The docket
then
did.
They clobbered the note, and you just gave it away to them, and that note has to be under public policy done away with, ineffective.
I'm not sure where it is.
Okay, what you should have done is put in chambers with a letter rogatory and put a notice of its existence through the clerk of the court.
Okay. I'll try to send you emails if I can ever get a few minutes of your time. I'd appreciate it off the show.
Okay. All right.
Thank you so much, Christian.
Sure. So we're back on the questions, have we established what the relationship is, and is it a trust relationship? And are the 4 elements there to create a trust? And is one of the 4 methods of formation there? That's number 3. And then you want to make sure that you created a title and used one on the UCC 1 and the county recorder to notice the existence of that title. In effect, you're claiming it first because you have to own it first in order to transfer it. And then 5, you want to claim that title. Let's see, what have we got here? I'm a little off here. 4 was make sure that you created the title. And 5 is claim the title on a UCC 1 and county recorded. Then number 6, you want to transfer the title. And then you want to give notification to all the parties also. Anybody else have any questions?
Go ahead. Star 8 on your phone, folks, if you have a question. It'll pop up my screen. I can go ahead and unmute you. Star 8.
And by the way, that is expressing the trust. And it's, and the key is really in the signatures, the rule of the signatures.
When you're talking about signatures, Christian, you're talking about restricting your signature. Is that correct?
Right. There's 5 types of signature. One is an unrestricted signature, which is just what they call a clean signature of the real man. Yeah, but anytime that signature appears in the public, they're going to construe it to be the straw man anyway. So what you did is you just gave everything back under public policy, under Federal Reserve note obligations and statutes and codes, because it's going to be construed under a debtor-creditor law, under UCC. Then you have grantor, trustee, and beneficiary, which is by grantor in the signature and by trustee in the signature, by beneficiary in the signature. And these by beneficiary, by trustee, by grantor, those are qualifiers. That's restricting the signature. So that makes the 4 signatures. And the 5th one is by authorized representative. And authorized representative can be construed 2 different ways. It could be under UCC, or it could be construed under trust. And by authorized representative under trust, you'd have to have a Form 56 appointment, either by the grantor or, say, the trustee, appointing that party as authorized representative as, say, co-trustee with certain duties, maybe under contract. But then that's another layer of insulation for that authorized representative party. And that's the 5 types of signatures. And they're all qualified except for one, which was the real man's signature, which was unqualified. And that is the keys, because you can look at that, and if you have a qualifier, that's like putting the notches or serrations on a key, that when you have the right notches on there, when you turn the key, it unlocks the door, and the door opens up. And you can just look by the signatures to tell whether or not you know who you are.
Exactly. We do have one caller who does have a question. Go ahead. You've been unmuted.
Hi, Kristen. I'm in the middle of a case right now, federal tax case, and I've appeared as the authorized representative throughout the whole matter, even at the arrest pleading. I don't have a Form 56 in. What I've done lately is I accepted for value the indictment and returned it for settlement and closure of the case. And I did this by private letter rogatory to the judge. And since then, just today, I felt that the judge, being the arbitrator, he's supposed to be fair and impartial, that I didn't want to involve him. So the prosecutor is the one that brought the charge, so I'm starting another administrative process with him and appointing him as the trustee of the constructive trust fiduciary, and sending a...
Okay, I got knocked off there, so I couldn't hear what you were saying.
Oh, I'm sorry. I'm in the middle of a federal trial right now on taxes, and I'm facing a bunch of charges. I did use the BIT instruments earlier with the DOJ. That was one of the charges they brought up. Anyway, originally I appointed the judge as I've appeared as the authorized representative, even at the arrest arraignment, and was not invited across the bar. Of course, the judge went ahead and entered a plea for the defendant, and I thanked him. Pardon me?
Can you kind of give me the question that you're going to ask, and then...
Well, the question I have is, I took the indictment and accepted it for value, sent it to the judge on the private, noticed all the parties, and just today, I went back and I'm doing an administrative process with the prosecutor and naming him as the trustee and sending him the instrument, the accepted for value indictment, true bill. And I guess my question is, and you probably answered it, I have not put the accepted for value indictment on a UCC1 or recorded it at the county. Can I do that after the fact?
Yeah, you can. You can always go back and correct your mistakes, but the trouble is, here's where we're falling down at. We never expressed a trust. You say you appointed a trustee, but trouble is, do you have a trust that you can appoint a trustee on that you expressed? If you didn't express the trust first, then the judge is going to say, we don't have a trust here. But that's the opening that you need to come in and express the trust. And after you express the trust, which would be your intent and purpose, and then you name the parties, and then you had the specific trust property, and you had the proper method of formation of the trust, say by declaration or transfer, and you had the documentation of the creating of the claiming and the moving of the title, and then when you transferred that title to the trustee, now you got valid trust.
Okay. So I'm missing a few things like intent and purpose of the trust.
Right.
Well, wouldn't that be, I said in the private letter rogatory that it was the accepted for value indictment was returned for settlement and closure to settle all the accounts. Wouldn't that be the intent and purpose?
Can you actually establish that there was a relationship, what it is? Can you name specifically, say, the three parties?
The grantor, the trustee, and the beneficiary?
Yeah, can you identify those parties? If you can't identify the parties, I don't think they can either.
Well, I would be the grantor of the trust and the beneficiary. Would I not?
All right. Did you declare that?
I didn't use those terms, no.
How about you mentioned the trustee? Now, did you have this specific trust property?
I got a certified copy of the acceptance for value of the indictment and accepted it for value and returned it.
And did we do the UCC filings and all that to claim the title? And then
no, I haven't. I'm sorry. That's where I fell down. I got to get the. That's what I'm asking you now. Is it too late after I've given him the instrument to go back and put that on the UCC 1 and 3?
Once you do the UCC transfer, it doesn't make any difference whether you actually physically delivered it to him. You know, he's had notice under 1-202. So it's officially been transferred to him, the legal title, and the legal title would be the actual representation of the document, which would be the specific res.
Okay. So
if there's no transfer of property, then there was no trust, and you can't have a trustee.
I'm sorry, could you repeat that? You were breaking up.
If there was no transfer of specific property to form the trust, then there was no trust formed, and then you have no trustee.
Okay. So I have to get the two witnesses that the accepted for value indictment was indeed the property.
Yeah, we're falling down on trust basics is what our problem is. We're declaring we have a trust, but we haven't formed the trust properly. We haven't expressed the trust properly. Or we haven't expressed the existence of the trust properly. Let's put it that way. Mm-hmm. So then we're assuming that there is a trust because I appointed a trustee. That doesn't qualify as a trust. You got to have the 4 elements of the trust and one of the 4 elements of formation in order for a trust to form. Okay. And then you have to transfer the trust property present now. Transfer that property to them. And then you have to own that property. In other words, you have to have claimed it.
Okay.
I think once we start doing that, then we can start going in with some enforcement because now we've got breach of fiduciary duty. We can come in, doctrine on unclean hands. We can come in with breach of trust as causes of action. And then we can come in equity and at law against these people for that. And I don't think they really want that. I think they're going to close and settle these cases down. I think this is going to lead to a higher consistency rate of success for us. And that's what our remedy is. It's NTT, New Trust Technology. It's really not new, but it's bringing it to light and understanding now, which is new. I mean, we've had trust from the beginning of the Bible because God granted a trust to believers.
Yes. Well, I have another question here. If I'm doing the UCC3, UCC1, UCC3, and the recording at the county, that is in the public, is it not?
Yeah, but I'm not recording the exact documents. I'm only recording the existence or a notice that existed of a private document exists, the actual document.
Okay. Gotcha.
Just a notice. This is actual and constructive notice of a promissory note number such and such and such, existing and held in the private.
Okay, great.
That's all I have to do is put a notice in on the public side. 2 witnesses, 2 registrations, 2 public notices, and one of them is a UCC and the other one's a county recorder. Pull them back out certified.
Yeah.
And then make copies of those and send them copies of that. And then record of my claiming. And then do the same thing again for UCC3 this time, which is the transfer of a partial or assignment or a full assignment to them. Now you've transferred the record to them. Now a trust forms at that point. Now they got liability.
I love it. I love it. So that's all going on to private to them. Yeah.
Yes.
Yeah. We at the last hearing we had done the judge appointment and the accepted for value indictment, and the first question out of his mouth I tripped up on. His question was, do you want this hearing to be public or private? And my logic was, well, I want public ratification of the agreement of the parties, so I think I better get this public. And I know I should have kept it private.
Yeah, I should have kept it private because that's where the substantive rights of the man are. The real man is to make private payment with private instruments in private, in chambers.
Yeah, I think I'm going to get a second bite of that apple, though, in about 3 weeks, because we're going to have another hearing, and the prosecutor's appearing by telephone, so it'll be interesting.
Well, better make sure you got all your dots and your I's dotted and your T's crossed. Make sure that you got the 4 elements of a trust there, and you can identify them. And you've got one of the 4 methods of formation of the trust, and the key one I'm keen in on all the time is either going to be declaration or transfer.
Okay.
Now you've got transfer of property in a real live trust. And now you got trustee's got duties and responsibilities that he can be charged for in breach of.
Okay. Great. Would you mind if I work on these documents in the next few days and then maybe email you? You could look them over and edit them or give me your comments?
Yeah, you got my email, movingtitles@hushmail.com.
Yes, sir. Thank you very much. I'm going to sleep better tonight.
Hey, Christian, as a side note to the recording of those documents, is it required to have them be in the county that the court case is in, or that you reside in?
I don't believe so, not unless you're forming a lien. You just need to create a record, some kind of public record that is going to appear in the public.
Okay.
You need the 2 witnesses in the public to make that noticeable to the public so the public can act on it.
So if it's pretty expensive in one county, but it's a lot less expensive and maybe easier to record in another county, it's probably okay to do that.
Well, you have full faith and credit, that's, and anywhere in the United States is, you can bring in from other counties, other states, it's...
As long as it's not a lien against a piece of real estate or something? Or any kind of property for that?
Yeah, a lien has to attach in the county where the property resides.
Got it. All right. We do have one other caller here from North Georgia that has a question, if you're ready to take another one, Christian.
Yeah, go ahead.
All right, North Georgia, you've been unmuted. Go ahead.
Yeah, I don't have a question, Christian, but the correction is Federal Rules Civil Procedure 902. The public record cannot be denied in a court case, any court case, state or federal. 902.
Right, and then you could also comport those to your local states, and that's codified in all local states also.
10.
And also, your notary certificate is also a self-authenticating document that cannot be classified as hearsay. It's outside the hearsay rule.
That's correct.
All right. Any other questions, folks? Hit *8 on your phone if you have another question or a comment for Christian. We'll give you guys a few more seconds here, and Christian, if you want to have any other closing comments, we'll go ahead and start winding down the call for the night.
Yeah, we're going to be implementing some moving titles and commerce workshops, teaching on-hand documentation on the NTT new trust technology. And if you want to join those and get information about them, send me an email at movingtitles@hushmail.com, and I'll send you some information on how to join those workshops. So again,
that's beautiful.
And request some information at movingtitles@hushmail.com. And again, the phone-in number for Saturday, my call on Money, Banking, and Trust by Moving Titles and Commerce is 712-432-8773, and the PIN number is 179441. So next week we'll talk about continuing on the trust, and we'll continue with the parties to the trust.
We do have one last-minute caller here who's got a question, if that's okay, Christian.
Okay, you might want to get Gilbert's Law Summaries, because that's what I'm reading from here. So that's on Trust by Edward C. Halbeck, Jr. It's a very good basic little book. It's about $25. You can probably get it at any law library or any bookstore.
Yeah, I found it online here.
Found it online, yeah.
Where you had mentioned Gilbert. Was that what it was?
Mm-hmm. Did you get a copy?
I have not ordered yet, but I'm certainly going to.
It's only like $26. It's pretty.
Yeah, that's about what it was. That's correct.
Okay, last question.
South Texas, go ahead.
Hey, thank you, Kristen.
Albert, how are you?
Okay, Kristen, how you doing?
Good, good. Nice to hear you again.
Yeah, same here. And, buddy, I'm just asking at what point will you be speaking about terminating, modifying the trust?
Well, we're kind of going slow, but yeah, I just touched on it today, because anytime that you merge the two titles in one of the entities of a trust, you terminate the trust.
Okay.
So if we would get our minds wrapped around basic trust principles, and I think a lot of people are really not grasping what I'm saying, but if they were studying a little more, a little bit harder, maybe they would get it a little quicker. Maybe they could start seeing what I see. I believe we have the total remedy to access the total straw man account, collapse it, and we don't have to really go through the DTC unless we choose to. I think we do it administratively without the DTC, because I don't have to join the DTC and go through a qualification of the DTC. I just need to tell the DTC who I am. I'm grantor, and terminate this trust and give me the funds.
Well, that's what I'd like to have a conference with you on. What I'm trying to identify is the actual trustee, I guess it would be.
The trustee on the Social Security account?
Right.
The straw?
Correct.
Well, I believe it would be the Secretary of Treasury or his successors or assigned. So whoever he is really assigned the duty, whether that be in the IRS or wherever they are, really doesn't matter to me.
Well, as you may already know, they are, I guess, putting their little Indians in front, and just all of them are returning all your paperwork. So
right.
There's got to be another step that we could take in order for them to do the fiduciary duties.
Yeah, but I really think we're missing some basic elements, and that's the reason why they're not doing the duties.
Okay.
Well, I think we're falling down.
Go ahead.
I think we're falling down on basics. That's our problem.
Well, I'll be listening to your calls, Kristen. Thank you very much.
Good.
Thank you.
You're welcome.
Excuse me. Can I have the email address again, please?
The email address is movingtitles, one word, @hushmail.com.
Is that fresh, F-R-E-S-C-H?
No, hush, as in Henry. Quiet.
H-U-S-H.
Yes, right.
Okay. And the name of the Gilbert's book again, sir?
The Gilbert's book is Gilbert Law Summaries, and it's Trust by Edward C. Halbeck, Jr.
H-A-L?
Halbach.
Very good. I thank you so much. I'm new at listening, and I'm trying my best to absorb as much as possible.
Okay, well. Anybody else have a question?
That looks like it. That's about it for the night, Christian.
Okay, all right.
So let's go ahead and close it down for the night, and then we'll resume next Wednesday. And folks, remember Saturday night, 7 p.m. Eastern Time. Be sure to get on Christian's main call to further delve into the world of trusts. Thank you. Have a great evening. Good night.
Thank you.